One Spanish. Oh, you're reading my notes. I love you. You're the best. You are definitely my flotation device in this sinking ship, that's for sure. I need you.
Good afternoon, Your Honor. This is Peresno Leon, certified Spanish interpreter. I have been previously sworn.
Hi, how are you? We have case number 2023-135101, Mr. Javier Fernando Romero Gonzalez. Is he here? Hold on. He's not in the room yet, so. Is he coming? No está aquí?
My apologies, Your Honor. Can I have the case number once again?
2023-135101.
Thank you, Your Honor.
I don't have that number. I have a different case number, Judge, for that. I have a 2023 CF 6036 AO.
I gave her agency case, that was agency case number. 2023 CF 60361. Is that what you have?
6036.
60, okay, AO, yeah, that's what I have. I just can't read the pen marks. Okay. Any recommendations on this affidavit bond situation for Mr. Javier Fernando? And let's appoint the public defender to all the initial appearances for the afternoon. Do you want to waive reading of the charges?
We can waive reading, Your Honor.
And so there's 4 counts, and it was no bond, and I believe there has to be a bond now, right? This is one of those.
Yes, Your Honor.
So,
Algo, si no había fianza, creo que ahora se debe de fijar fianza.
Yes, Your Honor. He is
Any
entitled to a
recommendations?
bond.
any recommendations?
No, Your Honor.
Okay. Count 1, 10,000, count 2, 10,000, count 3, 10,000, count 4, 10,000. No contact, no drugs, no alcohol.
Fianza se fija en $10,000 para el cargo número 1, cargo número 2, $10,000, cargo número 3, $10,000 y cargo número 4, $10,000. No puede tener contacto, no puede consumir bebidas alcohólicas.
Your Honor, I would also ask that he not return to the scene, which is the Innovation Middle School, and also have no contact with any minors, or at least supervised
Bien.
contact.
Yes, no contact
Bien.
with any minors and no return to innovation.
And Your Honor, he does have a nice hold.
If you may allow the interpreter to interpret. También queremos pedir u ordenar de que no regrese a la ubicación donde ocurrieron los hechos, Innovation, y no puede tener contacto con ningún menor.
Okay, thank you. This concludes your hearing.
Did that?
Gracias, eso concluye con su audiencia.
Was that just the one Spanish we had today? Okay, thank you, Mr. Interpreter. I'm going to hang up on you. Goodbye. Okay. Natalie Bertrand? Okay, waive.
I apologize, Your Honor. That was which case?
Bertrand, resisting without, misdemeanor,
Your Honor, can we reset this for, Your Honor, can we, she has no history. Is there any way we can release her ROR on this one?
state any objection?
No objection.
Okay, waive PC ROR. Thank you.
Thank you, Your Honor.
Thank you. Okay, Robert Crew? Okay, waive.
Your Honor, he does have a plea offer of adjudication guilt 7 days in Orange County Jail to resolve both his cases if we can reset this for tomorrow.
Okay. He's got open cases too that I'm going to consider.
I believe the offer was to resolve that 2023 MM000814 as
Okay.
well.
All right, reset it for tomorrow. Jade DeCruz? Is that you, sir?
This is Antonio Foreman, according to his name tag.
Okay, did Jade DeCruz bond out?
Miss Foreman.
Miss Foreman, apologies.
Antonio Foreman, that's you. Jade bonded out? Okay, thank you. Antonio Foreman, is that you?
Yes, ma'am.
Okay, you're here on a battery. There's probable cause in your affidavit. Your bond is set at 500. No contact with the victim, no return to 417 South Paramount Avenue.
All right.
Thank you.
Good luck with everything, okay?
Brittany Campbell?
I got one. Take this with you.
Okay. Waive, failure to appear, bond is 1,000. Yes? Waive, yes? Failure to appear, bond is 1,000 on a trespass. Chief, you refused.
Apologies, Your Honor.
Okay.
She has an offer to resolve her case if we can reset it.
Do I have to keep doing that?
I believe it would be in Your Honor's discretion in all candor to the
Yeah,
court.
I know, but I mean.
I understand.
They're refusing, I mean, how, I've been doing it all week, but I mean, at what point does it become somebody else's responsibility to get through? Like, they could have come up, but they refused.
Usually after the second refusal, I waive them because at that point, I understand it's their
Yeah.
choice. Sometimes I feel like the first day, they might not really know what's going on. They're not in the best state of mind after.
Yeah, I get it. Okay.
Your Honor,
Except
did you
for
have-
tomorrow.
Did you have 2 cases for Ms. Campbell?
Seems thick, let me see. Yes.
Okay,
Same thing, same thing, same thing.
yes, Your Honor.
Yes, so, okay, let's see if we can do it tomorrow.
And I'll be here tomorrow, so it'll.
Give her an extra day of credit time served. Okay, one for each case. Okey dokey. Jacob Craner? What's going on?
This is another adjudication of guilt, credit time
So
served
reset for
offer.
tomorrow? Okay, I'm gonna,
Yes, Your Honor.
I don't know, at some point, I'm gonna start denying it.
Understood.
The mornings aren't that bad. Jordan Garcia? Is that you? Okay. You have 2 counts. Give me 1 second. Can you explain this to me? Why does it say the same thing here? Is this the same offense? Original offense if known on BOP, fugitive FTA. What is, it's the same exact. So why did he, do you know why? You need the, habeas. All this here on is just the habeas, but he wrote it twice, so it's saying habeas warrant. All right, you have a capias on a lewd and lascivious battery, count 1, and a battery of a child, count 2. The bonds are no bond on count 1, 7,500 on count 2, and the conditions previously required are to remain in place, which is no contact with the victim, no drugs, alcohol, controlled substance prescriptions, no weapons.
Your Honor, I may have misread it when looking it up. Based on the age, I thought that count 1 was entitled to a bond, if state can
But it was a
confirm.
capias.
Oh, did I overlook that?
I think it's a warrant, Your Honor.
I believe it's a warrant.
I don't think it was an FTA.
Oh. I thought it was an FTA. That's why I'm getting confused, because it says FTA only on the arrest affidavit.
Oh.
Doesn't it say that at the bottom? Is it a, I only have a printout. Hold on, let me see. He has a private attorney? Has the case been filed on already?
Yes, Your Honor, information was filed.
And do we have any procedural history on it?
The information was filed April 13th, and a capias was issued, but I don't see where there was a failure to appear. Arraignment hasn't been set. Arraignment isn't set until the 22nd, Your Honor.
Okay, so the information was filed and a warrant was issued.
Yes, Your Honor.
Okay, thank you. All right, so count 1 is 5,000, count 2 is 7,500, and no contact with the victim, separate residences if there was, no weapons, no drugs, no alcohol.
You have a private attorney, so you can talk to them in more detail.
This was my attorney.
Yep.
I was told it was supposed to be up front.
Yeah.
Your Honor, he's stating that his private attorney may actually appear at 1 p.m., just as a heads up to the court.
What's his name?
David Redfern.
Bradford?
David Redford.
Okay, well, we'll keep it on the side if he shows up,
Redford.
okay? Okay, bye. William Ball?
He bonded, Your
Okay, William Ball bonded. Annie Britton, good afternoon, how are you?
I'm doing fine. How are you?
I'm good, thank you. Okay, you have a case, disorderly conduct, there's probable cause in the affidavit. Do you want to accept the state's offer today?
Your Honor, we would be asking if she can be placed on pretrial release. She just came in yesterday for a related case, and this was tacked on after the fact. She has absolutely no history, and she wanted.
Qualify for pretrial release? Okay, pretrial release, thank you.
Thank you.
No return to the scene.
Stay in
The
touch, okay?
courthouse, Your Honor.
Oh, is it really? Oh,
What?
Yeah,
okay.
it was downtown court.
That's funny. Okay, you can come back. I'd love to see you. Kayla Consuegra? Yeah, take it off. She's got to come back to court. That's pretty funny. Thank you for the catch. Kayla Alyssa Consuegra, bonded?
I don't have that one.
23012089.
Repeat that again, I'm sorry.
23012089.
Bonded. She bonded.
Thank you. Thank you so much. Jaden Edwards? How are you, Mr. Edwards?
Okay, how you doing today?
Okay, all right, you have two cases, and guess what? They're assigned to me, Division 61. How lucky am I? 2023 MM 3236 and 3235, trespass, count one, trespass, count two, and then the 3225 case is a petty theft. We have a offer to resolve these cases now.
Your Honor, I only have the 3-6 before me, and it was a withhold, credit time served, and no return.
All right, you're right, hold on. I just had two paper clipped together by accident. My apologies. All right, looks like we only have one case together.
Your Honor, he has no history. If there's any way we can, I don't think he qualifies for pretrial release, but considering the fact that he has no history in one other case that might need to be resolved. if
What's
we
the other
can-
case?
I thought that only one case was here today.
No, the other, that was my mistake.
Oh,
I had two paper clipped together. They both happen to be mine, but only one of them is him. Jaden Edwards, correct? Is that you? Right. So what do you want to do? Do you want to accept this offer from the state today on your trespasses? It's count one, count two, trespass. What is it? Adjudication?
No, Your Honor, it's a withhold.
He has no history, Your Honor, so it's a withhold of adjudication, credit for time served.
You
No,
want to do that to resolve your case? It's basically the lowest sentence I can impose. Withhold of adjudication, court costs, don't go back to, what is this? The West Club Apartments.
Your Honor, if we can ask for ROR as he has no history and probably wants time to speak with an attorney about this in more detail.
Your Honor, it's possible that he would qualify for PTD, but we'd have to do some more research, and there's paperwork.
Okay, did you want to see if you qualified for pretrial diversion?
Be completely honest, I've never been in court, so everything that you're saying,
Use the mic, I can't hear you.
I'll be honest, it's my first time in court, so everything that you're
Right.
saying is
Okay,
kind
so
of,
they'll offer you pretrial diversion. If you want to, you got to come back. You're going to see me you're going to see the judge at arraignment, and then you're going to come back and see me. You're going to have to come back here at least 2 more times.
okay,
They might be able to offer you pretrial diversion. It's a program offered by the state. You go do what they say to do, you pay for the program, at the end, they drop the charges against you.
okay,
That's option one. But you can't do that now because they got to figure out whether you qualify. They don't know that yet. So you're going to have to come back no matter what. You probably have to come back a couple times because Lord knows at arraignment, they probably won't have had enough time.
yes, ma'am,
So you'll probably come back at arraignment, you'll probably come back at pretrial conference, and then they'll offer you pretrial diversion, hopefully, but there's no promises. I don't know what's in your history. Or if you want to resolve it and never come back, it's a withhold of adjudication. It'll be on your record, but you can expunge it because it's a withhold or seal it, one or the other. And you got to pay your court costs. And then you can be done, and you don't have to come back. It's up to you. Those are your two options today. Which one do you want to do?
so for the second option, my court cost would be the
273 plus 50 for the public defender.
okay,
And I'll give you 6 months to pay. And if you can't pay within 6 months, you just have to come back and work out a payment plan with the clerk's office. But then you got to do your work, because it's a withhold, you'll have to do your work to expunge it. It's possible, it's not that hard. I signed them all day long.
yes, ma'am,
So, but it's up to you, which one do you want to do? Each one has its pros and cons. And if you want more time to think about it, that's fine too. Just tell me what you want to do.
Your Honor, he's informed me that he wishes to resolve it. I did not go over the plea offer or the plea form prior.
Okay, so she's going to give you a form. The form has all the rights you're giving up in exchange for your plea, such as your right to a trial, your right to call witnesses, your right to make the state prove this case against you beyond all reasonable doubts. You're giving up all these rights and some appealable rights if you enter a plea. Do you understand that?
Yes, ma'am.
All right, and do you understand that if you're not a U.S. citizen, entering a plea may subject you to deportation?
Yes, ma'am. I'm a U.S. citizen.
All right, yeah, but you understand that. I got to ask anyway. All right, so these are the big rights that you're giving up today in exchange for your plea. And you're going to be looking at a withhold of adjudication. It is a crime. The maximum penalties, I believe they're 2 second-degree misdemeanors. The state can correct me. Are they first or seconds? I always forget.
Trespass is usually a first, but I'll check to see. what
Okay,
is filed as.
so sometimes they're first. The maximum penalties are a year in jail, a year probation. We're not doing any of that. We're going to give you a withhold, right? So it's up to you. Does that make sense? Those are all the rights you're giving up today. That's what's in the form. Do you understand that?
Yes, ma'am. I understand.
Do you want more time, or do you want to, it's up to you.
You feel
I'll give you another 30 seconds to decide, because we're basically neck deep.
Another option is if he wants to take the plea form back there, I think they can hold him for a moment and we can recall it.
Okay. All right, you know what? For now, I'm going to accept the plea and not guilty for you. I tried, set the case for trial. I'll ROR you. You can go out, figure out whatever. Take the plea form with you. Take it with you.
Your attorney and more.
Okay. Thank you, goodbye. He doesn't have to come back. He can figure out what he wants to do later.
Call us, okay? That means you're gonna have to come back at some point, but not
Okay, Mitchell, Sky, Naya, Frazier.
figure out what's going on.
Thank
You're gonna
you.
head that way, of course. Didn't want to make you feel rushed into it.
Ronaldo Jose Golindan Hamana. Thank you. Heixuan Huang. Thank you. Oscar Morales. Wave.
Yes, Your Honor.
Okay. PC criminal mischief, $500 bond. Thank you.
No return?
No return. No return to 101 East Central Boulevard. Norfus, Tabitha Norfus. Okay. Oh, Christian Rueda? No Christian Rueda?
Was he mental health, the one that we spoke about earlier? Or medical? Yeah.
Your Honor, he does have a credit time served offer, though there are potential competency concerns. If we can just reset it so I can meet with him and verify.
What happened today?
He's not here today. I just had a note in an old
Okay,
file.
what was the do we know what the medical situation is? Is it a mental medical, or did he get hurt physically? Like, is there a chance he'll come tomorrow? That's what I'm trying to figure out. There's a chance? You're saying there's a chance? You don't know, I have no idea.
Yes, yes, see medical on the booking for, they haven't seen him, their system is down.
Oh, the system's down. Okay, it's like the Creole interpreter. Okay, so tomorrow we'll reset him. Thank you. Anyaya Javier Streeter? Okay. Tracy Sue?
This is Tracy.
Bonded. Yeah.
This is Miss Sue right here.
Hi, Miss Sue. I feel like I saw you already.
Yeah.
You're back. I don't know why. Tracy Sue, how are you?
Okay.
What did we do last time? Why are we here again?
And you don't, it's okay, you don't.
Sorry.
Let's see, what are we here for?
Anybody have any idea why Miss Sue is back again?
This is for a petty theft, Your Honor.
It's a new law offense.
Different from the defrauding that we did? Oh,
I believe, yes, Your Honor. This was yesterday, so yes.
was it yesterday?
Oh.
I feel like it was Monday. Oh, the petty theft was yesterday.
Yes.
Oh,
We did see her, though.
I feel like I just saw her.
She was here.
She was here, okay, I'm not losing my marbles. Okay. Petty theft, new case, yesterday. PC in the affidavit, bond is set at 500, and I'm revoking the defrauding an innkeeper charge. Thank you so much.
Your Honor, we would ask if the court is, one, inclined to revoke, that they revoke and double, and two, we would be objecting via the new case law unless Your Honor has consent from the judge in the case.
I have consent from the judge, thank you.
Your Honor, I would also ask for a no return.
No return, thank
It
you.
was $500 and then revoke bond.
Yes.
All right, you're gonna have to
Chad Sutton,
this, okay?
wasn't I the person who gave her the bond?
Your Honor, there is an offer in this case, and he does wish to resolve.
Okay, Mr. Sutton, you have 2 charges on this case, resisting and possession of drug paraphernalia. What is it, adjudication, 2 days jail credits for 2 days served?
Yes, Your Honor.
Okay, you want to accept the state's offer of an adjudication, credit time served, which is 2 days jail with credit for the 2 days that you served to resolve your case?
Yes, ma'am.
Okay, and did you fill out the plea form?
You just gotta sign.
You understand the form that you signed, it has all the rights you're giving up today, such as your right to a trial, your right to call witnesses, your right to make the state prove the case against you beyond all reasonable doubt.
Yes.
Okay, you're giving up all these rights and some appealable rights when you enter a plea today. Do you understand all that?
Yes.
Any questions?
Oh, Your Honor.
Okay, I find you understand the rights you're giving up today, find a factual basis, I'll accept your plea and impose the following sentence. Adjudication, 2 days jail with credit for the 2 days that you served. It's like a choreographed dance. Thank you so much. That's it, right? Thank you, goodbye. 6 months for your court costs. Vicky Trone? Ms. Trone, good afternoon, how are you?
Been better.
Okay, I find you understand, oh, sorry, wrong one. Skipping ahead to the second track. You're here on a petty theft, your bond's 500, there's probable cause in the affidavit. Do you want to accept the state's offer of adjudication? No.
No, there's no offer, Your Honor. This is enhanceable, and she has priors.
Oh, boy. All right, $500 bond, PC in the affidavit, no return. Good luck to you, ma'am. Ruh-roh. Okey dokey.
Your Honor, for this next one, she has no history. She has no history. We'd be asking for ROR.
Objection from the state.
Okay, is this Jabrisha Wallace?
Yes, ma'am.
Okay, Ms. Wallace, PC in the affidavit, pretrial release, don't go back to the 7-Eleven, thank you, have a nice day.
She doesn't qualify for pretrial release.
Oh, ROR, sorry. Wrong 3 letters. ROR, PC,
So that way you can talk to your attorney.
don't go back to 7-Eleven. Frank Hoffer. Hello, Mr. Hoffer, how are you?
Good afternoon.
Your Honor, this one does have a plea offer, and he wishes to accept it.
Okay, how many days? 2? 3?
Whatever, adjudication of guilt, credit for time served.
Okay. All right, Mr. Hoffer, you want to accept the state's offer of an adjudication, credit time served. It's going to be about 3 days, probably one for the,
It's 2 days.
2 days?
Oh, wait, no, sorry. This is a failure to appear, sorry.
So you're gonna have to serve 2 days, but you have credit for 2 days.
It's usually Madam Clerk who tells us what the credit time served is.
It takes another 5 minutes. I'll give you the 2 days credit for 2 days served. That we know for sure. Mr. Hoffer, you're giving up all these rights when you enter a plea. Your right to a trial, your right to call witnesses, your right to make the state prove the case against you beyond all reasonable doubts. You're giving up these rights and some appealable rights when you enter a plea. Do you understand that?
Yes, ma'am.
All right, any questions?
No, ma'am.
All right, I find you understand the rights you're giving up today. I'll accept your plea and impose the following sentence. Adjudication, 2 days jail with credit for the 2 days that you served. Your court costs are $273 plus $50 for the lawyer, and I'll give you 6 months to pay. If you can't pay within 6 months, just come to the clerk's office and work out a payment plan.
Yes, ma'am. Have a great day.
Thank you. You have a good day, too. Thank you so much. Melissa Maldonado,
Yes, ma'am.
how are you?
I'm okay, thank you.
Okay, all right, Ms. Maldonado, looks like you have this just one case. It's a petty theft with 1 prior conviction and a battery. It's by warrant. Your bonds are as follows, $2,500 for count 1 and $500 for count 2. Good luck to you, ma'am.
Thank you.
No contact, no return?
Yes, no contact, no return. Thank you, State. Robert Hill, is that you, sir? All right. Mr. Hill, you have a disorderly conduct. There's probable cause in the affidavit. Your bond's $250. Let's see if there's an offer from the state.
There's an offer of adjudication of guilt, credit for time served, and I did go over it with Mr.
You want to
Hill.
do that? You want to accept the state's offer? Adjudication, 2 days jail with credit for the 2 days that you just served, and that resolves your case, right?
Ma'am.
Okay, you understand you're giving up your rights to a trial, your rights to call witnesses, you're giving up all these rights when you enter a plea. Do you understand that?
Yes, ma'am.
All right, you have any questions for me?
No, ma'am.
All right, I find you understand the rights you're giving up today in exchange for your plea. Find a factual basis. I'll accept your plea and impose the following sentence. It's an adjudication court cost. Don't go back to West Colonial Drive, North Orange Blossom Trail, and you have to pay court costs and costs of a lawyer. I'll give you 6 months to pay, and if you can't pay within 6 months, don't worry, just come down to the clerk's office and work out a payment plan with them, okay? Thank you so much.
Ma'am.
All right, any final questions, sir?
No, ma'am.
Anything else for him?
No, Your
All
Honor, I
right,
just didn't
thank
have a
you. Have a
case
nice
number
day.
for this one at the top of the.
Oh, okay. Case number, got it. Gray, Encana Gray? Hello, sir, how are you? Looks like you failed to appear on a driving with suspended license charge. Is there an offer for him today?
Yes, Your Honor, the offer is a withhold of adjudication credit for time served. I discussed the offer and he wishes to resolve it.
Great, all right, Mr. Gray, if you enter a plea, you're giving up your right to a trial, your right to call witnesses, your right to make the state prove the case against you. You understand you're giving up all these rights and some appealable rights when you enter a plea?
Yes, ma'am.
All right, you want to accept the state's offer? It's basically a withhold of adjudication and court costs. We'll give you credit for the 2 days that you served, and your court costs are about $301 plus the attorney. It's going to be about $351, give or take a couple dollars, and I'll give you 6 months to pay, okay?
Okay.
All right, thank you so much. I find you understand the rights you're giving up today. I'll accept your plea and impose the following sentence: adjudication, 2 days, withhold of adjudication.
Withhold of adjudication, yes.
Credit for the 2 days that you served, plus court costs. All right, as soon as you sign that paper, I'll sign it too, and then you can be on your way.
And Your Honor, I did inform him that this is an enhanceable offense.
Oh, thank you. Okay, and you understood that, right? Okay, thank you, bye. Okay, Miss Kendall. Miss Kendall, is this the one that had a private attorney and a prior open DUI? Is that? Yeah? Oh, no info? So you know info the other DUI?
I did not.
Oh,
What was it, no pros or?
no. It was null pros?
Oh, is this the one that we dealt with?
Yes.
Okay.
Yes.
Yes, this had been null pros back in November, but the paperwork didn't make it to clerks, so it was still showing as open, but it has
Was it
been
a
closed.
pretrial diversion null pros?
No.
Just null
It was
pros?
just null pros.
Okay. All right, Ms. Kendall, you're here on a DUI in case number 23 CT 593AE. There's probable cause in the affidavit. Your bond is $500.
And Your Honor, I just wanted to confirm, because there's talk of a private attorney, the public defender is appointed for this one.
Yes, he's appointed for initial appearances today. Thank you so much. All right, good luck to you, ma'am.
Take this with you. This is your bond.
Jose Molina Duque.
Of course, that would be who you'd work with instead, okay? Okay, you might already be then.
I'm sorry, before we get started with the felonies, I had one other misdemeanor, J. DeCruz, 23MM313. Thank you. I didn't hear it.
Bonded?
I didn't hear it.
I don't know. Oh, I don't, did I?
The Jade?
Okay.
Jade.
I didn't hear it.
And then Melina bonded?
Okay.
Melina?
Are you Mr. Dustin Abergy?
Ma'am.
All right, you're here on a grand theft. It was from a warrant, and your bond is $2,500. That's all. Thank you.
So do you stay in touch with us?
Desmond Atkinson? No contact, no return. Thank you. I'm gonna get you like a prodder. Long prodder. With buttons. Electrocution, no electrocution, just pain. Pain and electrocution.
Oh, okay.
Yeah? Desmond Atkinson, is that you? Okay. All right, looks like you're here on a warrant, delivering of controlled substance within 1,000 feet, sale of fentanyl, possession of fentanyl. Your bonds are as follows: $10,000 for count 1, $10,000 for count 2, and $2,000 for count 3. The total is $22,000. No return to the scene. That's it. Let me just make sure. Yeah. All right, good luck to you.
Good luck with everything.
Mohammed Babamir, is that you? Yes, ma'am. All right. You're here on a warrant, fleeing and eluding. Your bond is set at $2,500. Thank you.
Look, your attorney in more detail. You're going to go out the opposite way you came.
Your Honor, we qualified Mr. Bartlett for pretrial release.
Okay, Joshua Bartlett, hello, how are you? Okay, any objection to pretrial release?
No objection.
Okay, you qualify for pretrial release, probable cause in the affidavit, pretrial release, and just seeing if there's a no return. I don't see any no return in here, so that's it. Thank you. Camille Beckett?
Conditions for you, okay?
Camille Leza Beckett?
Defender's office.
Okay, just hold on.
No, but you're going to have to stay in touch with your officer, okay? Good luck. They'll explain it to you. And, Your Honor, for Ms. Beckett, I do have a probable cause argument.
Okay, let's hear it.
Your Honor, defense would be objecting to lack of probable cause for the burglary as it was not established what the crime therein is. Arguably, if you were to argue that the criminal mischief was the crime therein, the criminal mischief would be seen as the entering. The crime therein must be separate from the entering itself. If you read the affidavit, she speaks of believing that she was meeting someone there, and there's no evidence, and that actually that she was allowed to be there, and there's no evidence that a crime therein was intended to be committed. And therefore, we'd argue it'd be a simple trespass.
State, what's your response?
Your Honor, there is the allegation that she was meeting someone. However, the owner of the property said that no one had permission to be in there, and I believe it's the fifth line down where it says, Island asked if he gave her permission to enter her residence, and he stated he did not. I understand about entry, but there were two criminal mischief. There was the front and the back. So if one of them was to enter into the property, the other one is just criminal mischief, Your Honor. And as the text message was sent, it's not just a simple trespass.
Okay. Motion denied. Probable cause exists in the affidavit for the burglary of a dwelling. Bond is $5,000. Criminal.
Your Honor, she does qualify for pretrial release. I apologize.
Okay.
Oh,
And no objection.
oh, I apologize. I have the wrong one up. I apologize. 5,000. Sorry, Your Honor.
5,100. Thank you.
No return, Your Honor, and no contact.
No return, no contact. Thank you. Timothy Clark?
You can talk to your attorney about any defense. Good luck. 5,100. Stay in touch with us.
Mr. Clark, good afternoon. How are you? Okay. You have 2 counts, assault and possession of a weapon or ammunition. There's PC in the affidavit. Your bonds are as follows. Count 1, 500. Count 2, 5,000. No contact with the victim and no return to the Circle K. Anything else? All right, good luck to you, sir. Marcus Cortez Ruiz. Lovely. James Crosby. All right, Mr. Crosby, you have 2 open cases. We'll address them in a minute. In the meantime, you're here on an aggravated stalking with a credible threat. Your bond in that case, since it was a warrant, your bond in that case is $20,000. No contact with the victim. No return to the scene. What else does it say? Hold on, let me read it. Oh, that's it? Okay. And now as to your CF cases, let me just see if they were filed on January 31st, CF 1403 and 346AO. Their drug charges, were they filed on, State?
23 CF 346 has been filed on. Pretrial is set for July 11th, and that's with Judge Brownlee. 23 CF 1403, he was arrested January 31st, has not been filed on. That's with Judge Madrigal.
Okay, so on CF 1403, no action since they haven't filed yet. And on CF 346AO, I'm going to revoke your bond. It's a 3rd-degree felony, and I have Judge Brownlee's permission. Thank you. Goodbye.
It's going to be held no bond right.
Duarte, Richard Duarte.
Yes, ma'am.
Hello, sir, how are you?
I'm too good over here.
I guess things could always be worse.
Yes, ma'am. It always could be worse. Always could be worse.
Yeah. All right. Well, on the positive side, there's bonds on your case. So I reviewed the affidavit. There's probable cause. You have bonds. Possession of cocaine, $2,000 bond, and resisting an officer without violence, $1,000 bond. That's it. Good luck to you.
You're gonna go out the other way.
Easy peasy. Nice to meet you. Have a nice day. Okay. Wayman Franklin? Wave?
Yes, Your Honor, we can waive.
Okay. 2023 CF 6140AO, possession of a weapon or ammo, $5,450. Grand theft of a firearm, $150. Cocaine possession, $150. Controlled substance possession, $150. Cocaine possession, $150. And case number 2023 MM120AE, possession of equipment, $500. Okay. Did I miss anything on these?
No, Your Honor.
No? All right, can't wait to meet him. He's assigned to me with his misdemeanors. We'll see what happens. Thank you. Maybe the felony judge will take care of it. Sean Kelly Gibson? Bonded, thank you. Racel Gonzalez Diaz? Hello, how are you?
Doing good on yourself?
I'm wonderful, thanks for asking. Looks like you failed to appear on a possession of cocaine, and the judge set your bond at $2,000, okay? All right, good luck to you. Madeline Gonzalez Pagan? Hospital. Okay, wave?
I believe, is this a PBL? Your Honor, if we can reset until she returns from outside medical, just due to the severity.
Okay, reset.
And if she's outside medical, sometimes what they do is the language will say upon return of outside medical. That way we're not just resetting it every day.
Okay. Lil Quincy Dwayne Grimmage, is that you? All right, sir, good afternoon. How are you? All right, looks like you're here on a possession of cocaine with intent to sell within 1,000 feet. There's probable cause in your affidavit, and your bond set at $7,500. Thank you.
And good luck with everything, okay?
Trey Havan Hodges Roman, is that you, sir?
Yes, ma'am.
All right, how are you today?
I'm fine.
Okay, you have two cases. Your first case, 2022 CF 11013A0, failed to appear on that case, and your bond has been revoked, and it's now no bond. On your new case, 2023 MM3231, providing false ID to law enforcement and petty theft. PC in the affidavit, $500 bond for each count. This concludes your hearing. Good luck to you, sir.
No return, Your Honor?
Yes, no return. Thank you. Joe Ortiz Lewis. Wave.
Your Honor, we can waive his appearance.
Okay. PC in the affidavit, attempted burglary of a conveyance, $150, burglary of a structure, $3,500. Open carrying of weapons and firearms, $150. Petty theft of $100 or more, $100. And no return. Arquin Mabry, is that you?
Yes.
All right, sir, you're here because you failed to appear for original charge of grand theft of a motor vehicle, and now you have no bond. Good luck to you, sir. Cassidy McConnell, how are you? All right, ma'am, you're here on 3 counts, petty theft with 2 prior or more prior convictions, fraud using personal identification, and fraud using a credit card. This is by warrant. Your bonds are as follows. Count 1, 500, count 2, 1,000, count 3, 500, total 2,000. no return. Thank you. Good luck to you. Alexi Mercado, is that you, sir? Mr. Mercado, good afternoon. How are you? Okay. You're here on 3 counts: possession of methamphetamine, possession of drug paraphernalia, and loitering. There's probable cause in your affidavit. Your bonds are as follows: 2,500 count 1, 500 count 2, 1,000 count 3. No return to the East Colonial Drive, North Bumby Avenue intersection. Thank you. Goodbye.
Doesn't look like you qualify for. Your Honor, is there any way we can reduce the bonds? He doesn't qualify for pretrial release, and I understand the court would not be inclined for ROR. However, he does have a job and gainful employment, and we don't want him to miss that. If there's any way the bonds could be slightly lowered.
Where does he work?
I work at Martin Roofing Company. Martin Roofing Service.
Martin Roofing Service.
Can I have that back for a second?
It is. I just pay my rent. I don't got no money to pay the bond at all.
He doesn't qualify for pretrial release?
We weren't able to verify community ties and residential information, Your Honor.
So if you verify it, then he qualifies?
Well, we tried to call, let me see. I believe
tried
he
to call who?
Contact. Let me see who it is. We tried to contact his mother. She lives in Arkansas, because it says that he's literally homeless, so.
Okay.
Okay, but when we interviewed you, this is information you gave us, so we're just going by what he gave us.
I don't have a problem if he qualifies for pretrial release, but I'm not reducing the bonds. Thank you. Good
Your
luck to
Honor,
you,
then
sir.
if it could read bond or pretrial release in case he doesn't qualify.
Yeah.
Okay, so pretrial release if you qualify, that's up to them. If you don't, then you would have a bond. So they're gonna re-interview you and see, okay? Good luck.
Okay. Hopefully you get better information this time. Argenis Ramos?
He bonded, Your Honor.
Thank you. Eric Rhymes? Hello, Mr. Rhymes. How are you today? All right, looks like you're here on a possession of cocaine with intent to sell and possession of cannabis. There's probable cause in your affidavit. Your bonds are as follows: count 1, $15,000, count 2, 100. You have an opened case. What's the status? 2023 CF 2102AO.
Pretrial is set for May 31st with Judge Wooten.
And is this a third-degree misdemeanor? I think it is. Throwing a deadly missile?
It's either second or third. One moment, Your Honor.
Okay, I'm going to revoke your bond on CF 2102AO.
And Your
Thank
Honor,
you.
for the record, we'd be objecting via Benoit
Yes.
versus Hoffman.
I have his authority to do it. Okay, Caleb Robertson?
Bond on your out on bond. Okay, so you're gonna have to talk to that attorney about what that means, okay?
Mr. Robinson, you're here on a petty theft, 2 or more convictions.
Bond it out on you. So I can rebond that on
You have no bond. You can't bond out, so talk to your attorney. Good luck.
Okay, say hi to Judge Wooten for me. Okay, Caleb Robertson, you're here on a petty theft, 2 or more prior convictions. There's probable cause in your affidavit. Your bond is $1,000. Don't go back to 880, the Target on West Sand Lake Road. Thank you.
Good luck.
Okay, Devon Ross, how are you?
yourself.
Wonderful, thanks for asking. All right, looks like you're here on a possession of a weapon or ammunition by a convicted felon. There's probable cause in the affidavit for the charge. Your bond is set at $5,000. Thank you. Good luck to you, sir. Theodore Earl Sherrod. Is that you, sir?
No.
No. What happened to Theodore?
Medical, Your Honor.
Theodore is medical. He failed to appear on a possession of something I can't pronounce. What is that? The,
Controlled substance.
yeah.
Yeah, pretty much.
I'm going to use that one again. A controlled substance. Waive?
Yes, Your Honor.
Okay. Failure to appear, warrant, capias, no bond. Thank you. Daquan Smith,
Ma'am.
how are you, sir?
All right, how you doing?
I'm doing well. You have a couple of things going on here. Case number 2023 CF 4814 has an obstructing justice, tampering with evidence, and then possession of a controlled substance. The bonds in that case, that's by warrant, and the bonds in that case are $1,000 for count 1 and $1,000 for count 2, total $2,000. Then you have another case, 2023 CF 6173AO, that's possession of fentanyl. The PC in the affidavit is there, and your bond for this particular case is $1,000. Good luck to you. Grayleen Lamonte Thomas. Hi, how are you? All right, sir, you're here on a possession of controlled substance, methamphetamine. It's by warrant, and the bond is $1,000. Good luck to you. Roberto Velasquez.
Your Honor, we did qualify Mr. Velasquez for pretrial release.
Okay, any objection to pretrial release for Mr. Velasquez?
No objection, Your Honor.
No objection. Mr. Velasquez, good afternoon, how are you?
You'll have to contact him from jail.
Can I tell him not to go back to the airport, or is that not allowed?
No return to the airport unless he has a valid ticket.
A ticket? We can't go pick up his mother?
That way.
No. No.
Okay. All right. So only official traveling business at the Orlando airport. Roberto Velasquez, there's probable cause in your affidavit. We're going to allow pretrial release. You can't go back to the airport unless you have a ticket for a flight.
Okay.
Don't go pick up your mother. Okay, goodbye.
Thank you.
Sheldon Wallen.
Take this with you.
Thank you.
And Your Honor, I believe this one actually came in under the wrong statute and under the wrong section, and it changes it from a PBL to being entitled to bond.
State response?
No, Your Honor, it is correct. What clarifies it to be a life felony is actually mentioned in the statute that's cited. It says that if the condition of E is mentioned, then it becomes a life felony. And if you go down to E1, it's if the person is physically incapable of responding.
Okay, so no bond on,
Yes, Your Honor, it is a life felony, and state is asking for defendant to be held no bond.
okay, no bond on.
And Your Honor, we would just reserve our right for an Arthur hearing downtown.
Yes, thank you. And it's 23 CF 6048. Is that the right case number? No. 2023 24060?
6048?
Which, because I haven't. No, the one we just did, the new one. Oh, yeah. So no bond on 24060? 48. There's no 48 there. Okay. Okay, all right, so there's that. Now, the old case, open, 2022 CF 14099AO.
Defendant was arrested January 20th. Formal charges have not been filed yet, and that is before Judge Harris.
Okay. And what do you want me to do? Take an action or let her do it? All right, no action on that. Let Judge Harris figure it out. Thank you, bye. Good luck to you. All right, and Keith Young. Hello, Mr. Young, how are you?
I'm good, ma'am. Yourself?
I'm good, thank you. Looks like you have an arrest warrant for a robbery and your bond is set at $2,000, no return. Thank you, bye.
Yes, ma'am.
Okay, take this with you.
Did I see a lawyer show up that needs some help?
That might be the,
Okay, was he for the Kendall woman? Is he for the Kendall DUI? Is that, oh no, he's
I
here
didn't
for
see
Jordan
him.
Garcia?
No? It may be for Jordan Garcia. No, it wasn't his?
Hello, sir, how are you? What case are you here on?
You're on Romero Gonzalez, but I think you addressed it.
I addressed everything, but I'm here to address whatever you want now. What case is it?
Romero Gonzalez is the last name, Judge?
Oh, the first one we did?
Yeah. He had no bond. Was a bond set on that, Your Honor?
I'll have to go back and check.
Thank you, Your Honor.
Actually, Oh, no, that's not the one. Never mind.
Javier Rivera.
10,000? Oh, 10,000 on each count, 4 counts.
Thank you, Judge. Nice to see you.
Nice to see you
See
too.
you in a while.
Thank you for your visit.
Have a good
Hi,
afternoon.
I told him you were coming, by the way.
Did you?
Yeah,
See if I can see him.
okay. He also told me you were coming.
Thank you very much, Judge.
Did waive reading? I waived reading, so it wasn't read on the. Before I knew he- I just want to give you a heads up.
No, PD is appointed already for purposes of IA, and I addressed the case. So yeah, goodbye for him. Okay, court's adjourned?
Nothing more from the state.
Anybody have anything else? Okay, no?
So I hope
All
not.
right, court's adjourned.
Thank you.
Yeah, will you? Afternoon, Mr. Raymond. I'm doing well. So my understanding right now from the NCIC information or FCIC information we have is you've got a warrant out of Polk County, and you're to be held on no bail until picked up. So you're going to be staying with us till in Osceola County Jail until Polk County comes to get you for a little bit, all right? All right. Thank you, sir. You can have a seat. Next, we got Jermaine Tyrone Wells. Afternoon, Mr. Wells. Can you hear me? Good afternoon, sir. Okay. Sir, you picked up, it looks like, because you got an outstanding warrant from Polk County as well. You're to be held at no bond until Polk County comes to pick you up. So you're going to be with us for a few days until Polk County comes to get you, all right? Next, we have Elijah Baltimore Dixon.
Your Honor, refused. Can we get a 24-hour reset, please?
I'm sorry?
He refused. May we get a 24-hour reset, please?
Oh, he refused. Okay. We'll reset Mr. Dixon for 1:15 or 1 o'clock tomorrow, and he's to be brought by any reasonable means necessary. Next, sorry.
What was the verbiage you said you used? Reset for 512 to be brought by any.
Reasonable means necessary.
Thank you.
Next, we have Jason Christopher Kemen.
President of Polk, Your Honor.
Afternoon, Mr. Kemen. It looks like you got a warrant out of Lake County, sir, and you're to be held at no bond until Lake County comes to pick you up. So they'll arrange to come transport you, but until then, you're going to remain there at the Osceola County Sheriff's Office, all right? All right. Next, we have Michael Grant Rogers.
He bonded, Your Honor.
Okay, now he was, I was gonna say, he pled yesterday. All right. That takes care of all of our out-of-county warrants. Next up, we've got 2023 CF 1409 State versus Robert Baker.
PD appointed.
Mr. Baker, sir, you have been charged with child neglect without great bodily harm. I have reviewed the original arrest affidavit and agree with the initial determination there is probable cause. I'm gonna set bond at $1,000. And as conditions of bond, you're to comply with all future court orders, appear at all future court dates, refrain from any new criminal law violations, You're not to consume alcohol or any illegal narcotics or prescription medication without a prescription from a physician. You're not to possess any weapons or firearms. You're not to have any contact with the alleged victim. You're not to return to the alleged scene of the incident. You're to maintain separate residences from the alleged victim. You understand?
Yes.
All right.
Next court date on demand.
Next, we have Chad Caldwell, case number 2021 CF 1284.
PD appointed.
Afternoon, Mr. Caldwell. Sir, you qualify for direct pretrial release. So I'm going to release you on non-monetary bond terms through the pretrial release program. You're to comply with all conditions of PTR. All right?
Thank you, sir.
All right.
Next court date, May 23rd in courtroom 4F at 8:30 a.m.
Next up, we got 2022 CF 1361, State versus Jason Chandler.
Good morning, sir.
What was that case number again, Judge?
It's case number 2022 CF 1361. Good morning, Mr. Chandler.
Good morning, sir.
We have a failure to appear at arraignment issued by Judge Carson. He's got you set at no bond. I'm not going to disturb his bond amount, but I'll let the regular division judge handle that if you feel the need to post or to seek bond. But right now, you're going to be held in no bond status.
Yes, sir.
All right, next up, we got 2023 CF 924 State versus Chastity Jackson.
PD appointed. And for the last case, next court date, July 5th in courtroom 4F at 9 o'clock.
Ms. Jackson is President Marshall.
Ms. Jackson, in this case, you've been charged with aggravated assault with a deadly weapon without the intent to kill, count 1, and count 2, battery. Having reviewed the warrant, I do agree there is probable cause. And I'm going to set bond in count 1 at $3,000 and bond in count 2 at $1,000.
Your Honor,
Yes.
I do see 2 counts of aggravated assault with a deadly weapon without intent to kill on my charging affidavit.
Oh, I'm sorry, you're right, there are. So in count 1 will be $1,500, count 2, $1,500, and count 3, $1,000. All right.
Any provisions, Judge?
And as conditions of bond, you're to comply with all court orders, appear at all future court dates, refrain from criminal activity, you're not to consume any alcohol or illegal narcotics, you're not to possess any weapons or firearms, you're not to have any contact with the alleged victim, and you're not to return to the scene of the incident. All right?
Next court date on demand.
Next up, we have 2021 CF 2703 State versus Taylor Harris.
Sorry, Your Honor, I don't have that individual on my list.
Okay, how about James Sam Mitchell?
Yes.
Good afternoon, Your Honor. Ray Mullins on behalf of James Mitchell.
All right, afternoon, Mr. Mullins.
Your Honor, first off, just for the court's verification there, they have him as a violent felony offender of special concern. He does not qualify as a violent felony offender of special concern because what they're doing is they're counting the robbery by sudden snatching under 812.131 as a regular robbery under 812.13. They can't do that. So he's not a violent felony offender of special concern. We actually cleared this up last time, I thought, And the state attorney who was prosecuting the first violation of probation, Mr. Collins, agreed with me on that. Robbery by sudden snatching is not a qualifying offense.
And that's the only charge that's got him qualifying as a violent felony offender of special concern?
I'm sorry, Ron?
Are you saying that that's the only thing that's got him?
As far as I know, that's the only thing I do not believe that he qualifies under any other statute or for any other violation in his history.
State?
Your Honor, I'm not sure. I'm not the ASA that was initially assigned to the case, so I'm not sure what Mr. Mullins was talking about regarding having a conversation with the other ASA. I do see that the initial charge is a robbery by sudden snatching. I did not see anything else that would warrant a violent felony offender of special concern.
Well, then great, we're in agreement.
Other than that may be the charge that they are talking about, Your Honor, that
So
makes
how
it
are
a
they?
felony offender.
So,
If you look at under paragraph 6, Your Honor, it says robbery or attempted robbery under 812.13, carjacking or attempted carjacking under 133.
Your Honor.
Hang on.
Okay.
First off, what does that have to do with the initial appearance today, number one? And number two, how can I do anything about that?
Well, Judge, if the court were to find that that's an error, then I think he could at least potentially have a bond set for his violation. Right now, if he's a violent felony offender of special concern, and this is how it impacts today's proceeding, is that he would be ineligible to have the bond.
That is correct, Your Honor. And state would argue that there be no bond because it is a violation of probation and let there be a bond hearing set with the trial judge.
Okay, I'm going to deny bond and leave it set at 0, and you can set a bond hearing in front of the division judge. But I don't know that it's appropriate at this juncture for me to even address the violent felony offender of special concern, because it's a designation made by the Department of Corrections, not by the court. So if they've made a mistake, that needs to be addressed administratively through DOC.
All right, thank you, Your Honor. That's all I have.
All right, thank you, Mr. Mullins.
Have a good day.
You too.
Next court date, May 18th, in courtroom 4F at 8:30 a.m.
Next up, we got 2022 CF 2331, State versus Billy Quintana Vega.
PD appointed.
He's present upon Chair.
Good afternoon, Your Honor.
Afternoon, sir. I have reviewed the uniform charging affidavit in your case, Mr. Quintana Vega, and it's already been found there's probable cause for the charge. I'm going to set bond at $1,000 is to count 1 aggravated battery causing bodily harm, and standard conditions of pretrial release and bond, comply with all court orders, appear at all future court dates, refrain from any criminal activity, do not consume any alcohol or illegal narcotics, don't take any prescription medication without a valid prescription, you're not to possess any weapons or firearms, or have any contact with the alleged victim, and you're not to return to the scene of the incident.
Yes, sir. Thank you, Your Honor.
Yes, thank you.
Next court date, May 23rd, in courtroom 4F at 8:30 a.m.
Your Honor. Just for clarification, you said PTR conditions as well, so he's bond plus PTR?
No, he doesn't qualify for PTR, just
okay.
as bond conditions.
Thank you, Your Honor.
Next up, we have 2023 CF 1418, State versus Clifford Beasley IV.
PD appointed.
He's in the cage, Your Honor. We can have him on.
Afternoon, Mr. Beasley. So you've been charged in count 1 with dealing with stolen property and count 2 violation of the Pawnbroker Act. The judge has already found there's probable cause for your arrest on these charges. And I'm going to set bond on count 1 at $500 and on count 2 at $500. All right.
Next court date on demand.
All right. Now we have 2023 MM1115 State versus Heriberto Almonte.
PD appointed.
Good afternoon, Your Honor.
Afternoon, sir. You, sir, have been charged with resisting an officer without violence. I've reviewed the uniform charging affidavit in this case. I do find that there is probable cause for the charge. I'm going to set bond as to count 1 at $500, sir.
Thank you.
Judge, he is on bond on 23 MM 60.
I'm not going to disturb Judge Epperson's bond at this point unless I have the written permission from Judge Epperson to do that.
Next court date on demand.
I'm sorry?
No action.
Yes, no action. Apparently there was a recent case out of the 2nd DCA that said that you couldn't revoke another judge's bond without their permission. Next, we have 2023 CF 1421 State versus Leon Crispin.
PD appointed.
He's in the cage, Your Honor. We can have a moment.
Okay. Afternoon, sir. In this case, the Public Defender's Office has already been appointed to represent you, but you've been charged in count 1 with domestic battery by strangulation and count 2 with battery. Having reviewed the uniform charging affidavit, I do find there is probable cause for the charges. I'm going to set bond on count 1 at $2,000 and bond on count 2 at $1,000. And conditions of bond are you're to comply with all court orders, appear at all future court dates, refrain from any criminal activity, you're not to consume any alcohol or illegal narcotics or prescription medication without a valid prescription, you're not to possess any weapons or firearms, you're not to have any contact with the alleged victim, that you're not to return to the scene of the incident. I will allow you to return one time with law enforcement to gain any personal belongings.
Next court date on demand.
Next up, we got 2023 MM1116 State versus Sergio Cruz.
PD appointed.
President approaching.
Afternoon, Mr. Cruz.
Good afternoon.
You, Ms. Ortiz? Okay. So, Mr. Cruz, you've been charged in this case with battery, and Public Defender's Office has been appointed. The alleged victim, in this case, is here to address the court prior to the court setting bond. Ms. Ortiz, if you'll raise your right hand, I'll have our clerk swear you in.
Do you solemnly swear or affirm that the testimony you shall give in this case to be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. Go ahead, ma'am. What is it you'd like me to know?
I would like to announce that I would no longer want him to be next to me or my kids. He's very, very violent, and he does not help with anything, and I feel safe with my aunt. I'm just gonna stay at her house for right now.
Okay. Is there anything else?
That's it.
Defense, any questions from Ms. Ortiz?
No, Your Honor.
State, any questions?
Do you have any items that you need to remove from the property?
I have my stuff there, yes.
You have your stuff, so you said you'll be residing with your aunt throughout the duration of this case?
Yes, I'm leaving right now.
Do you need to remove your things prior to Mr. Cruz returning to the home?
I thought he told me that you couldn't be at the house.
He may be able to be at the house if you are not there, if you're not living there. So that's why I'm asking if you need to get anything from the property before the judge may or may not allow him to go back.
Yes, I got my stuff.
Yes? Okay. No further questions, Your Honor.
How long do you need to get your stuff together and get out of there?
Maybe for like 5 days.
Okay. All right. So, Mr. Cruz, I'm going to grant bail in this case at $2,500. You do qualify for PTR with bail, so the standard PTR conditions would apply. But you're also not to have any contact with the alleged victim, Ms. Ortiz, and you're to maintain separate residences. I'm going to give her 2 weeks from today's date to gather her belongings out of the residence that you all shared. After she does that, then if you're still on that lease or that mortgage residence, whatever it is, then you'll be permitted to reside there, but you all are to maintain separate residences. Okay?
Your Honor, if I may briefly.
Yes.
Defense would ask for 1 week instead of 2 weeks. The home that the defendant, the victim reside in is Cruz's home. His name, his bills. So all of his belongings, he would like to return home as quickly as possible. In the alternative, defense would ask to kind of allow one time escort with law enforcement so that Mr. Cruz can.
Yeah, I'll allow a one-time return with law enforcement over the next 2 weeks to get personal belongings while Ms. Ortiz removes her belongings out of the house. And I'll order that Ms. Ortiz not remove anything of Mr. Cruz's from the house. And that way, basically that way he can go back and get things that he needs to last him for the next 2 weeks. And then Ms. Ortiz can get her things moved out of the house and then he can move back in.
Thank you.
Okay. Next up, we got 2023 CF 1423 State versus Joanna Jaimez.
PD appointed.
I'm sorry, Your Honor, what was that name?
Joanna Jaimez or James? I'm not really sure.
Thank you.
Good afternoon, ma'am. How do you pronounce your last name? Jaimez. Okay, Miss Jaimez. I reviewed your case, and you've been charged with burglary with an assault or battery. And I do find that there is indeed probable cause for the charge. I'm going to set bond in this case at $5,000. And the special conditions of bond are you're to comply with all court orders, period, all future court dates, refrain from any criminal activity. You're not to possess any weapons or firearms. You're not to have any contact with the alleged victim, and not to return to the scene of the incident.
Next court date on demand.
All right. Next up, we have 2023 CF 1425 State versus Jesus Montalvo.
He's President approaching, Your Honor, and I'd like to be heard as the bond.
All right.
Judge, his application, we couldn't he didn't complete it, so we don't know if he's appointed. So you can provisionally appoint if you
All right. So Mr. Montalvo's PD application wasn't completed all the way, but I'm going to provisionally appoint the Public Defender's Office as to this matter. And you said, counsel, you wanted to be heard as to bond?
Yes, Your Honor.
Okay. And I do find that there is probable cause for the charges, but as to bond, counsel, what's your position?
Your Honor, defense is requesting ROR due to the fact that Mr. Montalvo is currently incompetent. He has several cases, Your Honor, and I can list all the case numbers if you would like. There's 6 of them. He's currently incompetent on all of those cases. The most recent finding of incompetence was on May 2nd, 2023 by Judge Wilson. All of those cases have been transferred to competency court with Judge Lattimore, Your Honor. Although there has been no finding of incompetency yet in this new law, Blow versus State from the Southern Second District, Your Honor, 902, 340 from 2008, holds that a defendant is presumptively incompetent absent a hearing to determine otherwise. The court concluded that an individual who has been adjudicated incompetent is presumed to remain incompetent until adjudicated competent by the court. Additionally, a defendant's legal status as incompetent cannot change from incompetent to competent without the benefit of said hearing. So the defense will be asking for ROR, given the fact that competency follows the person rather than the case. That would be our request at this time.
State.
Your Honor, the defendant does have to be found incompetent in each individual case. He does have 2 outstanding cases right now, one that has been filed and one that has not been filed on yet that's just recently been received where he has been arrested. The defendant is on conditional release. If he's released ROR, he can't be placed on conditional release. I believe that the defendant needs to have specific conditions that he needs to be met in each case. The issue is that he keeps committing the same crimes. These are burglaries, petty thefts, that kind of thing. It may be due to whatever reasons that defense may be believing it is. However, because he continues to do this, he just keeps committing crimes and getting arrested. So until an actual finding of incompetency is made in this case, state would request that it not be set ROR, he have a bond, so that way conditions can be set for the defendant in each case.
Okay.
Whatever bond judge you find reasonable, but we would like bond with conditions.
Okay.
Your Honor, defense isn't asking for conditional release in this case. As indicated, he has not been found incompetent in this case, so there would be no reason to modify any conditions of release in other cases. Defense is only asking for ROR in the present case today, Your Honor, given the fact that Mr. Montalvo's legal status is incompetent, Your Honor, just as someone has their legal status is married, Your Honor. That does not change without some subsequent hearing or.
But he does have to be declared incompetent in this case, unless it's a permanent incompetency due to intellectual disability.
Your Honor, I believe it is intellectual disability, but I may have a second to confirm that.
Your Honor, that would need to be addressed in a competency hearing, not at IAs.
I can't address that at IAs. What I'm going to do is I'm going to set bond as to count 1 at $100 and count 2 at $1,000 with conditions of bond to comply with all court orders, appear at all future court dates, refrain from any criminal activity. He's not to consume any alcohol or illegal narcotics or prescription medication without a valid prescription. Not to possess any weapons or firearms, not to have any kind of contact with the alleged victim, and not to return to the scene of the alleged incident. I'm not going to address or touch the cases that he's out on ROR on, or that he's on conditional release for. Those conditions will remain in place.
Next court date on the man.
All right. Next up, we got several different cases. It's 2023 CF 1426, 2023 CF 1427, 2023 MM 1117, State versus Miguel Nieves.
PD appointed.
He's present in approaching, Your Honor. I would like to be heard as to probable cause as to, I don't know the order of your case, Your Honor. It will be the first case for me, the one with 5 counts. I'd like to be heard as to probable cause for counts 2, 3, and 5, Your Honor.
Well, I'm trying to see because I've got one that has, so,
Judge, she would be talking about 23 CF 1426.
okay. Okay. And just as to that case alone,
Yes, Your Honor, just as the counts number 2, 3, and 5.
and 2 would be burglary to an unoccupied dwelling, possession of controlled substance without prescription, and criminal mischief.
No, Your Honor, on my affidavit, count 2 would be possession of controlled substance without prescription. Count 3 would be possession of drug paraphernalia. Count 5 would be possession of burglary.
Okay. All right, go ahead, I'll hear argument.
Your Honor, Mr. Nieves is charged with possession of a controlled substance under Florida Statute 893.1, subsection 6, subsection 8. Possession or use of drug paraphernalia under 893.147, subsection 1. Possession of burglary was under Florida Statute 810.06. The charging affidavit indicates that the items giving rise to those charges were found it's unclear, Your Honor, inside next to a bike and a fanny pack, and then inside a backpack, Your Honor. At any rate, the statute for those charges all require that the defendant possess controlled substance or paraphernalia or burglary tool as applicable, Your Honor. And that the defendant knew the existence of those items and intentionally exercised control over them. The statute further indicates that control can be exercised whether it is carried on a person, near a person, or in a completely separate location. Mere proximity to a burglary tool does not establish that the person intentionally exercised control over it. The charging affidavit further indicates that the witness, Mr. Wooden, was in a foot chase with the defendant, Your Honor. I'm not sure for how long, but they were in a foot chase. The law enforcement noticed the defendant. He was running several feet away from the initial alleged crime, Your Honor, and that a bike was later located at the above-mentioned residence, where there was a gray fanny pack inside next to it, and then there was a backpack that contained items, Your Honor. It's very unclear to defense counsel exactly where this bike was located, exactly what type of bag the items were in, and it's so unclear that it does not, in my opinion, give rise to proper cause that Mr. Nieves was the one to have control or possession of those items. So that's what the argument for ROR as counts number 2, 3, and 5, and that case alone.
All right. State.
Yes, Your Honor. The bike and the bag that was located in which the substances and the burglary tools were in was next to the bicycle, was the bike that the defendant was pushing prior to entering the residence. And he left it, and Mr. Wooten, the witness, saw him pushing these items at the time that he started the foot chase. So they were in his possession. They might not have been in his possession at the time that the officers caught up to him, but they were in his possession, and that's how that they know that those items belonged to the defendant. So state would argue that they do know where they came from, However, if Your Honor is not inclined to take that argument, state request 24-hour reset so that way we can get a clearer picture from the law enforcement officers of what they were talking about.
Your Honor, if I may very briefly. The witness indicated that they saw Mr. Davis pushing a bike. I don't recall any mention of a fanny pack or a backpack. The witness also indicated that he was not sure where the defendant may have left the bicycle, just that he was pushing a bike, and then there was a foot chase, and then there was running, and then there was this bike, and next to it was a fanny pack and a backpack, Your Honor. So defense would maintain the argument that it's unclear if this bike even belonged to Mr. Nieves, if this is the one that he was pushing, and because there was no initial mention of backpacks or fanny packs, whether that belongs to him either or not.
Okay. I agree with the defendant's argument that there's, based on the way the affidavit is written, that there's not probable cause as to counts 2, 3, and 5. I'm going to give the state 24 hours to cure any defects, and we'll reset this for tomorrow at 1 o'clock.
Thank you, Your Honor.
I'm sorry?
2 through 5 are the counts we're resetting for?
Yes.
And you're
So,
finding PC on number 1?
yes, I do find that there is probable cause as to count number 1 and count number 4. And I'm going to set bond on count number 1 at $5,000 and bond on count number 4 at $500.
You're only gonna wait for tomorrow for the other 2 cases?
Yes.
Thank you.
Your Honor, I'm sorry, the other 2 cases you're not going to address, they're not related to the incident or the arguments that defense is making. I mean, you can if you want to, I just didn't know if you wanted to get it out of the way.
Oh, so the other 2 cases, 23 CF 1427. This is possession of a controlled substance and possession of drug paraphernalia. Okay. In that case, I do find there is probable cause. I'm going to set bond on count 1 at $1,000 and bond on count 2 at $500. Yeah, that's there's the so 2023 MM1117 count number 1, providing a false name or ID to law enforcement. I do find there is probable cause for that charge, and we'll set bond at $500.
Are there any conditions, Your Honor, on either of the burglary charges or the?
I mean, the standard conditions is the defendants to comply with all court orders, appear at all future court dates, refrain from any criminal activity. You're not to consume any alcohol or illegal narcotics or prescription medication without a valid prescription. You're not to possess any weapons or firearms. You're not to have any contact with, or not to return to the scene of the accident or have any contact with any of the alleged victims.
Next court date for all 3 cases on demand.
Next is 2023 MM1118 State versus Mariela Servin.
PD appointed.
Mr. President, approach.
Good afternoon, ma'am. You've been charged in this case with criminal mischief greater than $200 and less than $1,000. It looks like you were out on ROR on another case in front of Judge Epperson while this was committed. I do find that there is probable cause for the charge. I'm going to set bond at $500.
And you're not taking any action on the other case?
Correct. I'm not taking any action on Judge Epperson's case.
Next court date on demand.
Are there any conditions, Your Honor?
Just no return to the alleged scene of the incident, and to comply with all court orders and refrain from any criminal activity. Next, we have 2023 MM1120 State versus Mario Urgiles.
Katie appointed.
Victim's present.
Afternoon, sir. Can you hear me all right? In this case, sir, you've been charged with a battery. The Public Defender's Office has been appointed to represent you. Having reviewed the charging affidavit, I do find that there is probable cause for the charge. But I understand that the alleged victim is here present, and you'd like to make a statement, ma'am?
Yes, I just.
If you can just raise your hand, I'll have our clerk swear you in.
Do you solemnly swear or affirm that the testimony you shall give in this case to be the truth, the whole truth, and nothing but the truth to help you God?
Yes.
Go ahead, ma'am.
Yes, I just going to drop the case. I'm going to continue. We have conversation already to start taking marriage cancellation, so to try to fix our life.
Okay. I'm going to set bond in this case at $1,000. And conditions of bond, Mr. Urgiles, you're to comply with all court orders, appear at all future court dates. You're to refrain from any criminal activity. You're not to consume any alcohol or illegal narcotics or prescription medication without a valid prescription. You're not to possess any weapons or firearms. You're not to have any hostile contact with the alleged victim. Because she's indicated that she does want contact with you, I'm not going to make you all live in separate residences. And you also qualify for PTR with bond, so standard PTR conditions would apply as well.
Your Honor, may State inquire some questions to?
Oh, you may.
Thank you. If anything like this were to happen again, what would you do? Are you in any fear?
No.
Okay.
And I have another question.
One second. Is it related specifically to the contact?
Yeah, I don't have any issues with you contact me.
Okay. State would still request no contact, Your Honor, as it's been a short time. There were multiple bruises on the victim. I believe she did state that there was prior instances in the to the law enforcement on the day. Just wanted to make a record of that, Your Honor. And I believe she did state she had a question if the court wants to.
What's your question, ma'am?
Yeah, the question is, I don't have any issues with him coming back to the house. So because we don't even live here, we live in Jersey. So I don't have any problem, so he could come back home.
Will you be leaving for Jersey when this case is over? Are you going back to Jersey?
Yeah, we're going back to Jersey. We're supposed to go back to Jersey tomorrow.
Okay, thank you.
All right. The court's ruling will remain there's not to be any hostile contact with the victim.
Next court date on the man.
All right, next up we got 2023 MM1121 State versus Kelsey Williams.
Yeah.
2023 MM1121.
The victim is present, but she has nothing to say.
Okay. Good afternoon. In this case, you've been charged with a battery, and I've reviewed the charging affidavit. I do find that there is probable cause for the charge of domestic battery, and I'm going to set bond at $1,000 with conditions of bond. You're to comply with all court orders, appear at all future court dates. You're to refrain from any criminal activity. You're not to consume any alcohol or illegal narcotics or prescription medication without a valid prescription. You're not to possess any weapons or firearms. You're not to have any contact with the alleged victim. You're not to return to the scene of the incident, and you're to maintain separate residences.
Yeah.
Yes.
If I may, I did have a chance to speak with the alleged victim prior to the hearing. She does intend to leave the residence. She just needs time to get out. So she has no objection to the defendant going back once she's moved.
Okay.
I just wanted to put that on the record.
That's fine as well.
Judge, do you want me to put the same condition as the other one for 2 weeks? Next court date on demand. Because he refused yesterday, so you reset him, and they were supposed to bring him by any means necessary.
Next up, we have 2023 CF 1382 State versus Christopher Nicholas Wilson.
He's in the case, Your Honor. We can have a moment.
Yeah.
And defense will wait for formal reading of the charges.
Afternoon, Mr. Wilson. So in this case, you've been charged with 4 separate crimes. The defense has waived reading of the formal charges. I've already found that probable cause exists for the charges. But for count 1, it's going to remain at no bond. Count 2, bond's going to be at $50,000. Count 3 at $50,000, and count 4 at $4,000.
Next court date on demand.
Now I'll get our interpreter on the line.
Good afternoon. This is Claudia Villalba, court interpreter. Can you hear me?
Yes, this is Judge Beamer. We have some guests joining us from the jail, so we need the assistance of the interpreter over the loudspeaker, if you can help us.
Yes, of course, Your Honor. There's a lot of background noise, but okay, it's better now.
All right.
Interpreter is ready, sir.
Our first case is 2023 CT 2178, State versus Enrique Caballero Reyes.
He bonded, Judge.
Never mind, that individual bonded out.
Okay.
Next, we have 2023 MM1119, State versus Marioli Suguera Perez.
PD appointed.
Mr. President, approaching counsel.
Your Honor, just to clarify, we're doing this over the loudspeaker and not through the headphones, right?
That is correct.
Very well. Interpreter is ready.
Good afternoon, ma'am. You've been charged in this case with a battery, domestic violence.
Buenas tardes, señora. En este caso, a usted se le ha acusado de un acto de agresión, de violencia intrafamiliar.
I've reviewed the charging affidavit and find that there is probable cause.
He repasado la declaración jurada por escrito y hallo de que existe un motivo fundado.
I'm going to set bond at $500.
Le voy a fijar la fianza en la suma de $500.
And as conditions of bond,
Y como condiciones de su fianza,
you're to comply with all court orders,
va a tener que cumplir con todas las órdenes del tribunal,
appear at all future court dates,
tendrá que comparecer a todas las citas que tenga usted en el futuro ante el tribunal,
refrain from any criminal activity,
deberá evitar participar o involucrarse en cualquier tipo de actividad delictiva,
and you're not to have any hostile contact with the alleged victim, your cousin.
y no podrá tener ningún tipo de contacto hostil con la presunta víctima, en este caso, primo o prima.
State.
Your Honor, state would request that there be no contact, especially since the alleged victim is not here to determine whether or not she would like to have no hostile contact with the victim, or I'm sorry, with the defendant.
Su señoría, yo voy a pedir de que en este caso se prohíba todo contacto, especialmente en vista de que la víctima no está aquí presente para decir si ella quiere tener contacto sin hostilidad o no con la víctima. Perdón, quise decir con la acusada.
Given the facts of the alleged incident, I'm going to keep it no hostile contact.
En base a los hechos del incidente que se alega que ocurrió, voy a dejarlo así, voy a prohibir que haya contacto hostil.
Next court date on demand.
La próxima cita ante el tribunal tendrá que esperarla para cuando se fije.
Next, we have 2023 CT 2183 State versus Julio Vasquez Núñez.
PD appointed.
Señor Julio Vázquez Núñez, se le nombra el defensor público.
Good afternoon, sir.
Buenas tardes, señor.
You've been charged with operating a motor vehicle without a valid driver's license.
A usted se le ha acusado de manejar un vehículo motorizado sin tener una licencia de conducir válida.
Having reviewed the uniform charging affidavit, I do find that there is probable cause for the alleged offense. And I'm going to, go ahead.
Y al repasar el affidavit acusatorio, determino de que existe un motivo fundado para respaldar este presunto delito.
And I'm going to set bond at $200.
Y le voy a fijar la fianza en la suma de $200.
Next court date is still in jail, May 18th, if out, May 30th, in courtroom 4A at 8:15 a.m.
Si sigue detenido, la próxima cita ante el tribunal va a ser el día 18 de mayo. Y si todavía está, si ha podido salir en libertad, será el día 30 de mayo en la sala 4A a las 8:15 de la mañana.